come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office? Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm supporting...
What is your legal proposition?
My legal proposition is this, that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your proposition,
I think you should read the law first, Khwaja
this
Sahab,
is-
and then formulate the points.
let us first formulate.
Act पढ़ लीजिए, उसके बाद
फिर एक-एक को
it
देखें।
is only 2 pages act. It is only...
Let me follow the Chief Justice.
Khwaja Sahab,
Let me read the law and then we make my submission.
If I may make your job easier, undoubtedly it's sometimes very difficult and disconcerting if
I know it's very difficult to answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires a constitution, that's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take, and when you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. Okay? So, please continue with the act.
Just can you take down the points and so that you can answer them. Second part of this section 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other 2 members of the committee as the case may be. The decisions of the committee shall be by majority. Now this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and promulgating, we would certainly refer to item 55 of the Federal Legislative List, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be.
Argue as you want.
Well, all right. I'm just saying that your Lordship should note item 55 of the Federal Legislative List.
Let's read it together. You wanted to read it. Let's read it.
We'll read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. Before going to this entry, if you want, you may read Article 191 of the Constitution. What it says?
191 also. In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70 gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the Federal Legislative List may originate. I will skip that. I'll go straight on to subclause 4 of Article 70. In this article and the succeeding provisions of the Constitution, Federal Legislative List means the Federal Legislative List in the 4th schedule, sir. Then there is Article 141. Subject to the Constitution, Majlis and Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142. Subject to the Constitution, Majlis and Shura shall have exclusive powers to make laws with respect to any matter in the Federal Legislative List. Then I take your lordship to 191, which is to the effect subject to the Constitution, again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
These powers are under the Constitution, your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also, I'll come to that also. Because when I read 55, then it will be clearer.
Khaizab, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my lord that what will be my proposition, and also what Justice Mansoor Ali Shah has said, that how will I go and make my propositions, and to say how this law is not obtainable. But may I read 55 as it states?
Please do.
Because your lord may ask questions on that. 55 of the Federal Legislative List. It says jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Khaizab, just read it as is. Don't interpret it. Then you can interpret it.
Okay, I'll go along with that. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution.
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों की समाअत जारी। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली मर्तबा फुल कोर्ट की समाअत पाकिस्तान टेलीविजन न्यूज पर बराह रास्त नशर की जा रही है। पीटीवी नेशनल पर इस वक्त भी फुल समाअत की कार्रवाई बराह रास्त नशर की जा रही है।
निगरान वज़ीर आज़म अनवारुल हक काकड़ का 5 रोज़ा दौरा अमरीका। न्यूयॉर्क में अक़वाम मुत्तहिदा की जनरल असम्बली के 78वें इजलास से खिताब और आलमी रहनुमाओं से मुलाकातें। मौसमियाती तब्दीलियों से मुतालिक अहम कॉन्फ्रेंस में भी शिरकत करेंगे। निकरा वज़ीर-ए-आज़म दौरे में बैनुल-अक़वामी ज़राए इब्लाग के नुमाइंदों से मुलाकातें और अमरीका के मारूफ थिंक टैंक्स का दौरा करेंगे।
To regulate this procedure, as has been done in the past, as has been held in a number of cases which we bring before your lordships. Those cases are well known.
Now I'll just ask a question. You can note it. Are you suggesting that that even the rules of 1980 are ultra vires the Constitution? Please let me finish. Because the power vests in the Supreme Court as all the judges of the Supreme Court. That could be one reading of your argument. So you are saying that Section 2 is ultra vires of the Constitution, which gave power to 3 persons. Order 11 of the rules is ultra vires because it gave power to 1 person. Is that your proposition?
No, madam. My proposition is very straightforward. As far as the 1980 rules were concerned, they were made by a full court which was at that time. And that has been very beautifully explained by my Lord Justice Maleeb Akhtar in one of the judgments, where the entire historical perspective has been given. My proposition is slightly different. These, under 191, it is the function of the Supreme Court itself to regulate its thing.
Okay.
See, 184.3 is not the only part.
Bajwa Sahab, you can later answer my question. So what you are suggesting is that the expression subject to the Constitution and law, this becomes redundant? That is the question. That is what you are interpreting it.
I'll answer that. We'll answer that. We noted, we'll answer this thing. But my basic question, why I came before your lordship, is that the functions which are there with the Supreme Court, there should not have been there with the Parliament. Because that institution that has its own. Today they say that how you are going to have the benches. Tomorrow they will say that such and such bench will hear this case, such and such bench will hear that case.
No, please let's not go into what they may or may not do.
Why I'm saying is this, that if I give them unbridled power, then anything can happen.
Bajwa Sahab, the matter it pertains to your attack on a particular piece of legislation.
But I will say this thing.
No. What Parliament decides to do future, you can bring another petition, we can look at it then. Restrict yourself to your case. Please proceed.
I will say this thing then, that this clause 2 is beyond the powers of the Parliament. Three, and when I'm arguing, my associate will explain that 184.3 is not the only thing which is regulated by the Supreme Court rules. If your lordship would have the 1980 Supreme Court rules in front of you, there are the different types of jurisdiction which are available to you.
Shall we finish with the Act quickly?
Oh, okay, I'll finish with the Act, my lord. Exercise of original jurisdiction of the Supreme Court. Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 of the Constitution is involved, it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. I will simply say on this thing that this is...
Sir, on your right side, but not as much right as previously.
Yes, my lord.
Over here. Question, so your associates can note this. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power, or is this a judicial power, or is this an administrative/statutory power. Because 184(3) is ultimately a judicial power. Because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power but an administrative power. So can Parliament whittle down? This is a question, please note.
Yes, it's noted, sir, and in fact, that is exactly, that will be exactly my proposition.
Please hear his lordship.
Sawal to sun le. Can the Parliament whittle down the judicial power under 184(3) by providing that this committee will act as a gateway and block out in exercise of administrative power anything that the committee feels, 3 judges, not the whole of the Supreme Court, but 3 judges, senior most respectable judges, but in the end just 3 judges, block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. So you kindly note the question and you address it at an.
And I will go even further than that,
and also a supplementary question connected to this. Earlier, the Chief Justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you, that one person can actually control the outcomes of the cases by constitution of benches, and this probably was the mischief that the Parliament wanted to address.
If I may add, there is a judgment of this court and there is a judicial pronouncement on that as to what procedure would be followed by the Chief Justice to invoke jurisdiction of this court under Article 183. And it says where a bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of public importance affecting fundamental rights, they may recommend to the Honorable Chief Justice that a bench be constituted. And the Honorable Chief Justice, after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would record reasons why he thinks he disagrees with the recommendations, or thereafter he can proceed. And so there is a judicial pronouncement on that already in place.
In fact,
Sir, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what the supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power. But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the 3-member committee exercising administrative powers to actually block the exercise of judicial powers. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this, so this is not a question of composition of benches, that is power conferred universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? question is maybe noted.
And
You don't have to answer.
I'm not
Please
answering.
carry on.
I'm not answering.
The Honorable Chief Justice said you carry on with your submissions. Just note the question.
This thing. I will add one thing to it. It also deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I'm being condemned. I'm not being heard.
Who is
the party is not being heard.
Who is when you're using the word I? Who is the I here?
Litigant. The litigant.
Because एक second, sir. Tahammul. The litigant. That leads me to another question. Are your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest?
No, I am looking at Section 3.
No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge, or they brought it in the public interest? What is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know, we want to see.
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I'm speaking for the petitioner, and I'm saying this thing that we brought this petition in the interest.
You got the answer. Now please proceed. I've got the answer.
You got in the interest that the law should take its course. The Constitution must be upheld. And I'm also saying that I'm sure with such preliminary sitting there, the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please. We are not going to platitudes.
I will not make a political speech.
Khwaja Sahab,
I'll refrain from that.
Just proceed with that.
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship has possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
let us clarify. Is it your argument that Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's what my point. 2 and 3 have to be read independently and separate.
Now, please.
And 2 an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine. But I mean, please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
To be very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I would say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000. I will continue. Let me continue.
Let
me continue.
Mr. Khwaja, I will add it.
Then is the question.
Mr. Khwaja.
Yes, sir.
Right side.
Right side. Okay.
I will add to it. Whether the power of the Supreme Court has been curtailed or the power of the Chief Justice has been. I think that's the moot question.
The answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is Chief Justice and so many other judges.
will be sitting here till 12 o'clock.
I know that, sir. Let's
अपना argument करें. अभी तो हम section 3 पे पहुंचे.
Let me, on section 3, I will only say this thing, that this certainly is, the Parliament has taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition. I've not even heard, and 3 judges or about 2 judges, they will decide on an administrative side, and I'll be out. So the question of 184(3) will become totally redundant. This is my point. Therefore, to that extent, section 3 is. Then next is 4. Interpretation of the Constitution. In the matters where interpretation of the constitutional provision is involved, committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object? First say, I object to this provision, or you endorse it?
I will say this, sir, that in the matters of interpretation of the Constitution, when you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7, why not 6?
Please.
I object to this thing, that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just safe? Is this ultra vires the Constitution, section 4? Say something, we should note it.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges. Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5, then there's a question of appeal, and which is a very relevant point.
Khwaja Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not, sir. I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. About how the benches are to be. I will.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir.
This is your suggestion.
No, sir. I'm saying this thing that under the 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the Parliament.
Okay, now let's proceed. We'll ask.
I'll argue on that. That is the point which needs consideration. 5 is appeal. Yes, Marisa.
On section 4.
On 4.
If memory serves me right, section 4 what is the equivalent of Section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendments? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question. Please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी। जी मैं इधर हूँ जी।
जी सर।
भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए, सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए कि जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में मैं बाद में जवाब देता, ठीक है? अदरवाइज तो आप आपकी मुश्किल काम हो जाएगा।
मैं आई एम क्वाइट आई हैव वेरी
नहीं आगे बढ़ते हैं।
I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
मुझे कोई प्रॉब्लम नहीं है। I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask, recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you. Surely, the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
Not through ordinary legislation.
आप नोट कर लें।
If I will really request my colleagues that they are making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं. Let me say this.
Mr. Khwaja,
Khwaja sahab, section 5 से आगे पढ़ लीजिए.
Another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत आर्टिकल 199 के लिए अपील प्रोवाइड की गई बिफोर 2 member benches. वी आर फॉलोइंग इट. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहां तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199, हियर आर्टिकल 183, 84(3). तो ये क्या दोनों में ये गलत है तो फिर वो भी गलत है.
It is noted. We'll answer this thing that what Parliament can do and what Parliament can do many things. My Lord has said so, but there is a procedure provided. We'll answer that.
भाई साहब अभी जवाब की जरूरत नहीं है. आप प्लीज
I will not answer it.
पहले एक्ट को खत्म कर
Section 5 से आप आगे बढ़ लीजिए. ख्वाजा साहब, you have collected 100 questions.
Just here. The law reforms ordinance of
How you will
1972.
answer?
This is the question to you. Regulated right of appeal within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clog is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent, which is now no longer there, and also the clog was only in relation to Supreme Court. Question: is therefore the law reforms ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clock.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under Clause 3 of Article 184 of the Constitution prior to the commencement of this Act, provided that the appeal under this subsection shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will.
What you have to do, you're not going to do it.
Well,
you have challenged the law. You have to do. You have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
Well, my lord, as far as Section 5 is concerned,
is it good? Is it bad? First, tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184(3), then why is this not they included in Clause 2, whereby my 184(3) application will be disposed of?
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
Then let me explain it to them, because if I start explaining it at a stage, it will take your time. But I will say this thing, that this Section 5 should have also, this right of appeal should also have been given in Section 2.
Should is different from ultra vires a constitution.
It ought to have been given.
What then? You go and move a bill in Parliament. We are saying, are you opposed to Section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे.
You have done this.
नहीं, ये नहीं, आप जवाब दीजिए ना. आपने petition लाए. This is not fair.
इसमें, to make it more simple, you don't want your client to have a right of appeal.
No, sir, I
First say it's unconstitutional, it's constitutional. You're not saying anything, you just... यहाँ कोई discussion होता है, sorry, not on. This is your job in office.
My Lord, may I say this thing that we divided the...
Please answer the question, is this constitutional or unconstitutional?
It is unconstitutional.
I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
Unconstitutional. Well, it's my personal opinion is this, sir, that this Section 5 goes beyond the powers which were there with the Parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my Lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under Section 184(3).
Okay.
And this appeal through this act, an ordinary law, cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions. Please let